That review petition, the Supreme Court has said the entire selection therefore had to be invalidated to maintain the sanctity of the process of selection, which should be pristine and free of all such inferior. However, the interest of the appointed candidates who were untainted were sought to be protected to the greatest extent possible, as is evident from the concluded paragraphs of the judgment. Greatest extent here means that this has to be protected. Experience. Now, this is the experience part is also there.
5th of August?
Pardon?
5th of August.
5th of August. 5th of.
The supplementary affidavit has been filed as 5th of August. Spiral compilation. 1 minute. 5th of August order is there? Yes. Page 281. Is the spiral compilation. 281. 281. Which portion did you read?
Well, this is at paragraph 4.
Paragraph 4?
Paragraph 4, last few then. Above
yes, the adverse remarks.
The entire selection, therefore, had to be invalidated.
The entire selection. Yes.
Therefore, had to be invalidated to maintain the sanity of the process of selection. We should be pristine and free of all such information. However, the interest of the appointed candidates who are untainted were sought to be protected to the greatest extent as possible, as is evident from the concluding paragraphs of the judgment. No doubt, invalidation of such untainted appointments would lead to heartburn and anguish, which the court was fully conscious of. But protecting the purity of the selection process is paramount and necessarily has to be given the highest priority. Last but not the least, the adverse remark made against the authorities concerned who are wholly and solely responsible for the adverse appearances applicable of kind of were fully warranted and justified. Now, the protection, this is
whatever is protected. That nothing the court has not given you anything else.
Here has not been clear, but this
goes against you rather.
Protection to these 10 marks which have been given.
You give protection, but at what stage is the issue now? Now may I just take you, my lady? Yes, Schedule 2. Schedule 2. My lady's question on academics and academic score. Yes. Singular and plural. Right. Now, this is only English grammar. How are you in academics? Means English, math, so on and so forth. What is your academic performance? What is your academic score? That is the only distinction. Tell me one thing. How are you interested in this matter? No, I am in 4 IAs before you. Yes. Untainted candidates. Maybe. All of whom have prior experience. Now I'll tell you, I'm answering my lady's second question. Right. You see, we all have prior experience. Some of us may have 3 years. Some of us may have 6 years. So inter se in this category, if you even look at the rules, I may get 2 years for 1 year's experience. I may get 6 points for 3 years experience. Right. Now please see. Now please see. May I just take you back? We are just on interpretation right now. Not on merits. We're on interpretation. Give a copy. Give a copy. There was direction for circulation of
correction. She is not even a party.
I am in items 9, 10, 11, 12, 14.
In 10, I have made him party.
Who have you served, madam? Who have you served? The councils are here.
There was a direction on the last occasion.
Yes. Give copies of who did you serve? Give copies of the affidavit. Who did you serve? The councils are there. Item 9, who did you serve?
14.
No, item 9.
9 and 10.
We are in 9 and 10. They're identical, my lady. Right, 9 and 10. Who did you serve? If there is no service, then I'm not going to hear you at all. Show me. This is the service. Please, Onake Dakhan.
9 and 10.
9 and 10, check out whether service has been effected or not. If not, please hand over copies. Yes, madam. Yes. So, on points of academics and academic score, because the rule could not have said academic score. It has to, it's a composite. It's just English grammar, my lady, nothing more. Academics has 2 components. So, therefore, Schedule 2, the title, has to be academics because there are 2 components to it. Component 1 is educational qualification. Component 2 is the prior teaching experience. Both these are academics. If you ask my son, for instance, what are your academics Like, what's your performance? And of course, he runs away when I ask him this. But it will be more than one: math, English, PE, so on and so forth. What is your academic performance? What is your academic score? That is a composite. So it is only on English. It is not contradictory. Nothing needs to be read out. That's the first submission. Now, please see the second submission. Please go to prior teaching experience, 10 marks. My lady has that, schedule 2, 2. At the secondary level in a government or government aided or government sponsored school, calculated on the basis of 2 marks for each year of service in a substantive post as permanent or contractual basis. So this could include those who are not part of the 2016 recruitment cycle. This could include those who are part of it. This could include those who are in government teaching positions, or this could include those who are on contractual positions. So
No,
the
it's
net
all
is
right.
very wide.
All said and done.
Yes.
Is stage. You get the marks.
Yes.
What stage?
Now the stage. Now please go to rule 11.
Yes.
Rule 11 makes it clear, and then I'll come back to 2K and 2L. Rule 11, my lady has this.
Yes.
In my compilation, it's 541, but be
I
that
have
as it. Method of SLST for selection of candidates and preparation of the panel. The method for selection of candidates. Now, please turn the page over. Please see the sequencing that happens. Rule 10, this is 11, subclause 10, my lady. Preliminary list of shortlisted candidates. Step 1. Thereafter, 11. Regional Commission shall verify the credentials. So at this point, I have taken the exam. I have given my educational qualifications, which are in academics. Please see, that is in Schedule 2, academics. So at this stage, 11, there is a verification of Schedule 2 that is happening. This is Step 2. Step 3, 12. The Regional Commission during document verification in case of any doubt on disability. So any other specified categories, there may be other categories also. Step 4, so 3 continues. This is verification of documents. What documents? Educational qualifications. This is criterion 1 of academics. Now please go to 15. The Central Commission, Regional Commission submits these report to the Central Commission. The Central Commission, after we have finished this process of academics, which includes educational plus prior teaching. Now step 3. After this, the Central Commission shall prepare a consolidated interview list, which shall be published and be forwarded to the interview board. After academics has been assessed, this composite list, step 3, is sent to the interview board. Step 4, the final step. After the interview board shall forward a detailed report to the Central Commission, which shall, from the interview list and on the basis of the report of the interview board, prepare and publish a merit list. This is the final stage. The culmination of 1 to 4 is step 5, which is the merit list, which, my lady, is L. That is the final stage. The rules are harmonious. We may have belabored its explanation, but the rules are in consonance with the steps which the rules provide for. It is in consonance with English grammar, and it is in consonance with the idea that a seminal idea which the Supreme Court has long upheld. It is within executive and legislative domain to fix qualifications. There is no preferential treatment here. We are choosing the best possible teachers. That includes educational qualifications, that includes prior teaching experience, that includes performance in the interview.
Very well.
I have a direct answer for your questions.
Yes.
My first point is it is absolutely clear when in the rule itself there may not be any requirement of any kind of interpretations. Kindly see first 11 Roman 8. But this is the substantive part of the rule. There is a difference between definitions for the purpose of finding out what does it mean and what is to be done. Now, what is to be done at 11.8, kindly look at two things, presence and absence. Presence of K and absence of N. So, 8 equals to, if I read, the Central Commission shall prepare and publish in its website a preliminary list with details of candidates to be called for interview.
So therefore, pre-interview. So there is no confusion. Subject to verification of credentials, it's not relevant. And eligibility category-wise, on the basis of, now this is preliminary merit score as defined in Rule 8(1)A. Lordship conspicuously finds that it's not the definition of merit that is not there. The definition of interview list that is incorporated. And Lordship kindly come to straightway schedule itself. But when Lordship's query is at what stage? 1 first, 2 second, 3 thereafter, 4, and that's the thing. Kindly follow that the simplest thing, schedule 2, A equals to capital A equals to the entirety what is required to be done. It's not what exactly pre-interview, all. Now 1, 2, 3, 4, kindly come 1. Exactly that was the beginning written, done. 2. Now 2 has 2 components. 2 has small a and small b. Now kindly see thereafter 3. So chronologically, this 3 for 9, 10 and also for 11, 12, it is coming after 2. If I just say once more, there is a clear chronology under the schedule. 1, 2, 3, 4. Yes, 4 ultimately ends at lecture demonstrations. So there, my lord, the oral interview comes as 3, whereas the prior teaching is coming under 2. So the question before your lordship is at what stage? It is at the stage of pre-interview because of the 2 reasons. Reason number 1,
When is the interview going to be held? Any idea, Commission?
well, it has to be after the list is prepared.
That I understand. How soon are you expecting to prepare the interview list?
The verification process will go on for till 17th, 18th. Well, I'll take
Till?
instruction till 18th. Well, I'll take instruction
Is it after the 26th
well, I'll take instructions.
or before that? If the
Tentative schedule, my lord.
Advertisement they have given, but
that is not being followed,
that is not being followed.
assuming the Supreme Court interferes and says that 10 marks will not be there, as was submitted by Mr. Mitra on the last occasion, then the stage issue comes later on.
Stage issue, may I say?
Right.
I'll take instructions, sir.
May I just conclude? My lord, the stage issue can only come if there is any kind of confusion, as was sought to be said.
Now they are raising
Now
confusion
they are raising,
issues.
correct, they are raising. I'm not saying that they are not raising, but once lordship look at from this angle, when it is clearly said as 1, 2, 3, 4, and 3 equals to oral interview, now then lordship has to somehow change this rule. I'm not saying that is impermissible, but that's a different thing altogether. As far as the
You say this is the chronology, they say that is the chronology.
no, I don't say the chronology is the only reason. I say this is the chronology. So the rule itself shows that before oral interview, it has to be calculated. Number 1, and the direct answer is the substantive. The substantive says 11:8. I would be only praying before lordship to see the absence of L, because their entire submission is on the basis of definition of merit list. That comes later on. Lordship kindly see that in Roman 8 there is an absence of, so therefore how interview list has to be made, that is clear. Nobody is required to interpret it. They could have simply said you also add the M. You also add the L. They have not. So where merit list comes, kindly look at Roman 16. Much after. And if you lordship kindly take the definition, it would be clear also. The merit list is something which comprises of everything if there is a requirement. It is not a double marking at all. Because for primary, that chronology is different for the prior teaching experience. That's they thought it. Kindly look at my lord, this K. So K is the clear answer. What should be the interview list? Number 1. and that says on the basis of the preliminary merit score. Now, where the preliminary merit score comes, is it before oral or after oral? Schedule 2 is clear. Now, their entire submission, if I take it, is they're banking on L. L equals to merit list. Now, if Lordship kindly see a definition of the L, it is possible to say that there is some kind of, if I say, a contradiction. But that is contradictions in the definition clause, not in the substantive clause. Substantive clause 11 Roman 8 clarifies that this list has to be done on the basis of the K and K only. And in that context, assuming that, my lord, there is a confusion, there is a direct judgment. That this judgment, my lord, takes this part. Kindly take the definition clause 2. This is the kind of rule which begins with 2-1. Kindly take, my lord, 2-1. In these rules,
I'll fix this matter later on. Please come. Submissions made on behalf of the parties, including the applicants' interveners, at length. Stop. Release the matter once again on 28th of November 2025. Supplementary affidavit filed on behalf of the petitioner in the matter of Rahul Mondal and others be taken on record. Stop. Next. In the last day's order, it has been recorded that the fate of the examination will abide by the result of the writ petition. That order remains. So that order continues. And just wait for the Supreme Court to make any type of interpretation, or if you all can get hold of any one line which says that this court can go into all these things, then with an open mind, the court can decide. Otherwise, it's always playing at the back of the mind that anything will touch that 10 marks.
yes.
Anything, any order passed here will touch that 10 marks issue.
But this issue would never be gone by the Supreme Court.
Suppose the court says that the 10 marks will not be there at all.
That is fundamental.
That is the main thing. Then no question of former, later, now, later.
But if the Supreme Court says,
Right, then this is there and the interim order is also there.
okay,
10 marks, they can always calculate. Let us see.
The original order will abide by. There is no reason.
Yes.
This is not that kind of matter that they can seek a stay of entire proceedings.
Nothing of that sort.
On
Yes.
20th November, one clarification, will my lord hear me or not?
I will certainly hear you.
Okay, then you will.
I have heard you. Today also I have heard you. And I'll hear you on the next day
I
also.
would have avoided all the complications.
You have, sir.
How to read a statute, that's
Yes.
the question.
Yes, sir.
That's
Next
the-
day. এক minute. 9. Yes. For what? No, sir. You must be filing your intervention application. That is on record. What affidavit will you file? What affidavit will you file? Your application is in your support. What further application will you file? Don't add up documents. All right. Can যতগুলো আছে না allow করে দেব।
My lady, just one
The
small
documents
point.
to be circulated, did you? Interveners.
Yes.
What about the copies? Did you get it? Copies?
Yes.
Other tans?
My lord, I have not received.
See, somebody
will
has not
please
received.
give
Please
copies.
give.
My lord,
Please give.
Don't be stingy on photocopy.
to avoid-
Copies.
My lord, they involved in the 4 matters, my lord. All the matters we have solved and I have the evidence of this matter.
See, the court is not concerned with the affidavit.
Any of the
The paper should be there. The court is happy.
Hand
A
over.
question of law.
Copies.
But to avoid further confusion, logically record note, this issue does not relate to the constitutional validity, but relates to the applicability of the rules.
The last day's order, what is the issue is clearly recorded. I will not add anything.
My lady, my submissions are for all the cans that I'm appearing in, my lady.
So you file it today, you file it on the next day, it will be the same thing.
Yeah, so it's the same submissions for all of them. We've got them very briefly for my lady's consideration.
Give it, it is the same thing.
Yeah, it's the same thing in all the cans.
Same order will go down in item number 10.
My lord, only one thing, your lordship is allowing these
9, 10,
applications.
11, 12, 14.
They'll
Yeah, my
let
lord.
be added because I'm hearing them.
Yes, my lord, only one thing, then department may be directed to amend the cost title because
cost title amendment করে interference
Right now,
এই হিসেবে
interference হিসেবে থাকছে
let them remain. Let them remain. They have been allowed to participate in the proceeding.
My lord.
The court has heard them.
Yes,
Right?
my lady, I hope I'll be able to come back to my lady's court.
Please
Hopefully.
do.
That's
And
my,
enjoy the city.
That's my hope. Yes, I'm
It's
grateful.
a nice weather right now.
Beautiful city.
Please do.
Grateful.
আমি জানি না